Hi, and welcome to Class Module 14, Title IX, and Gender Equity. Let's turn our focus onto policies and regulations that we're required to enforce and abide by, some of which we can control, many of which we cannot. But ultimately, we as administrators are responsible for institutional compliance with these. We're going to look at the definitions of each. We'll start off with policies. The most general of organizational guidelines, policies are flexible, subject to some interpretation by managers, and are introduced primarily to influence managerial actions. I'll give some examples. At the high school level, maybe there's an admissions fee that must be charged to all athletic events to everyone who attends. Or at the college level, drug testing or transportation only on a charter coach, which is something specific to our landmark conference so that coaches won't drive their athletes in cars or vans. Or at the professional level, maybe there are restrictions to alcohol and food being brought in to a venue or an arena. So when thinking about policies, I want you to think about some examples of policies that you've either encountered or that you can think of at a collegiate athletic institution. Maybe they're conference policies or college policies issued which might affect you, either through employment, maybe it's moving allowances or vacation, could be flexible leave days. Other policies may be departmental policies that are put into place or that you would inherit as an administrator. Think about how you may take control of these and then maybe how that you or your staff may be affected by them. We're going to talk about the definition for regulations next. This is an authoritative issue of guidelines for employees to follow and is usually originated by higher management or government. Could be at the federal level, or if we think about at that level, job safety guidelines issued by OSHA. Thinking of some regulation examples that may be encountered by a college athletic administrator, well, at the national governing body regulations, the NCAA, or at the federal government laws and regulations. The one federal law which impacts you as an administrator most, and one you need to be most familiar with, is going to be Title IX. Now, you may be most familiar with this as it relates to sexual misconduct and assault, but it clearly has far-reaching implications for higher education beyond that tight focus. Now I want you to think about your impressions of Title IX, maybe thinking back to your experience and understanding and how you first gained knowledge of Title IX. So in 1972, Title IX was passed as part of the Education Amendments. What it states is it must be seen in the context of the larger scope of equality. The Civil Rights Act of 1964 gave far-reaching rights for the first time to individuals and essentially gave teeth to the 14th Amendment to the Constitution, protecting the civil rights of all Americans. The Civil Rights Act addressed rights in the areas of voting, public transportation, access to hotels, theaters, sports arenas. It addressed employment and hiring practices, etc. Title IX did not occur in a vacuum. It came out as a result of a long series of legislation, laws, and court decisions. Equality before the law and freedom from discrimination was not a single specific act. Instead, it was a long, gradual process that moved most often kind of like a glacial speed. And Eventually, it started to gain ground when demonstrations and riots were common in the big cities and major metropolitan areas. Title IX states, no person in the U.S. shall, on the basis of sex, be excluded from participation in or denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. In passing the law, the federal government had two objectives: to avoid the use of federal resources to support discriminatory practices, and to provide individual citizens with effective protection against those practices. After passing the amendment, it took the federal government almost 3 years to write and publish the actual law in the Federal Register, and almost 4 more years before the Office of Civil Rights published the final guidelines on how it would interpret and enforce the law. As far as the law is concerned, it became effective in 1975. It applied to elementary, middle schools, high schools, colleges, and graduate programs. All institutions required to complete a self-evaluation. And they had an adjustment period until July of 1978. In December of 1979, the Department of Health, Education, and Welfare issues its final policy interpretation and gives the enforcement of it over to the Office of Civil Rights. And the OCR, in determining if equal opportunities existed, said it would consider the following 11 factors. Number 1, selecting sports and levels of competition accommodate the interest and abilities of both sexes. Number 2, equipment and supplies. Number 3, games and practice times. 4, travel and per diem allowances. 5, coaching and academic tutoring. 6, locker rooms, practice and competitive facilities. 7, medical and training facilities and services. 8, housing and dining facilities and services. 9, publicity. 10, assignment and compensation of coaches. And 11, financial aid to athletes, athletic scholarships. Since then, 2 more have been added to bring the total number of factors to 13, with the 12th being support services and 13, recruitment of student athletes. It has had a history of starts and setbacks. Title IX's first decade brought about a revolution in sport with an explosion of participation opportunities for girls and women. The 1970s also included attempts by lawmakers to amend the law to either exclude athletics altogether or at least remove men's basketball and football from the law's jurisdiction. In 1976, the NCAA filed a lawsuit against Title IX. And in 1980s, the decision in the court case Grove City versus Bell, 1984, meant that the law only applied to units in educational institutions that directly received federal funds. Since few athletic departments received federal funds, almost all athletic departments in the country did not have to comply with Title IX. This was the case until later in the decade when Congress passed the Civil Rights Restoration Act. This took place in March of 1988 when Congress overrides President Reagan's veto of the Civil Rights Restoration Act of 1987 that broadened the definition of Title IX and essentially reversed the Grove City College versus Bell decision by providing that any institution receiving federal funding must not discriminate in any program offered by that institution. As a result, the focus of litigation shifted from the scope of Title IX jurisdiction to the real issue of determining whether sex discrimination exists and finding ways to correct it. The 1990s featured a dramatically different climate for Title IX because of a new government emphasis on enforcing the law as well as the passage of the Equity in Athletics Disclosure Act in 1994, which required institutions of higher learning to annually report data about their men's and women's athletic programs. In April of 1992, this began a series of cases brought by student athletes at the NCAA institutions. LSU had 3 women file suit demanding the athletic department add women's soccer by the fall and softball by the following spring. The court said that LSU had failed to follow through with what it said it would do: add programs. Federal Judge Doherty issued an interpretation which resulted in the 3-pronged test, which I'll explain in just a minute. Brown University cut gymnastics, volleyball teams, as well as men's golf and men's water polo based on 40% of the athletic opportunities available to women, while its student body consisted of 50% female. The court required them to add 4 varsity programs, and the list goes on and on of colleges and universities which were turning their programs around. In the first decade of the 21st century, Title IX and athletics were in the headlines many times together. President Bush appointed a commission on opportunity in athletics, and in 2002, to study Title IX, a move many feared would have an attempt to weaken the law. In 2003, the commission reaffirmed the law, but in 2005, the Department of Education issued a clarification stating that colleges and universities could prove they were meeting participation needs on their campuses by using an email survey. President Obama rescinded this clarification in 2010. Now back to the 3-pronged test. An institution need only meet one of these 3 methods in order to comply. Our first, participation opportunities, substantial proportionality. Essentially, an institution must provide opportunities that are substantially proportionate to their respective rates of enrollment. At first, it was instituted that 5% enrollment be acceptable for proportionality, but subsequent interpretations suggested that it be closer to 1%, and this has caused great concern and difficulty with complying. Our next one, and any one of these, if you answer only one, you don't need to move down the list to comply. Second, demonstrate a history and continuing practice of program expansion for the underrepresented sex. No fixed amount of time to respond, and the OCR wants to look at the entire history of the program. Key question is whether the college has been responsive to developing interests and abilities of the underrepresented sex. Our third, or fully effectively accommodate interests and abilities of the underrepresented sex. Determining unmet interest is requirement. How? Well, by reviewing on-campus programs in club sports, intramurals, you get the gist. Survey student body. Email survey ruled to be an acceptable way to gain feedback from current students. And are there recruits playing these sports in areas where you typically recruit? Here's what happened and the trends that are visible because of the changes through Title IX for women's programs. A couple of the stats you can see in this slide here. 1 in 27 were the number of girls that competed at high school programs in 1979. That number is now 1 in every 2.5. There's over 3,700 programs that have been added at the college level for women, but also I want you to notice that there's almost 1,000 men's teams that were added. And you can see the numbers here that women in sports in 1972 was just over 30,000, where it's grown so much for college athletes that we're over 150,000. For the next slide, we're going to look at a report done by Acosta and Carpenter. It's a 35-year study about the entitled women in intercollegiate sports from 77 through 2012 and 2014. And you can see the average number of female teams per NCAA campus at about 8.3. That's gone up from 2.5 in 1970. 383 men's programs have been added, while 331 men's programs were dropped. So there's still a gain of programs at the college level for the men's programs, which was not the thought to begin with and what Title IX would accomplish or try to do. In Division I, 26 men's programs were added and 235 dropped for a net loss of 209. Here are some of the stats that you can see of the programs that were dropped. Wrestling, swimming, tennis, and gymnastics were some of your top programs that were taken out for increasing equity within campus communities. On the women's side, we have almost 2,000 women's programs were added and 71 women's programs were dropped. Primarily, we look at programs that were badminton, fencing, and skiing. So almost 2,000 programs were gained through that longitudinal study. Now we're going to talk about the Equity in Athletics Disclosure Act of '94. This is a great example of a federal law which was passed, the Higher Education Act and the Equity in Athletics Disclosure Act, now having an impact on every athletic department in the United States. It became effective in October of 1996, and every year each institution needs to submit a report by October 15th. Federal law requires that all athletic expenditures and revenues be made public. The elements of this report: total number of participants, percentage of participants, head coaching assignments, and comparing full versus part-time staff, as well as assistant coach assignments, full versus part-time. Operating expenses, meaning the dollars and the percentage per capita. And then recruiting expenditures, athletically related student aid, revenues raised by men and for women, the average salaries of head coaches, men versus women, and the average salaries of assistant coaches, men and women, and then the overall revenues and expenses. In this slide here, we can see a comparison of men's programs that were discontinued and women's programs that were discontinued versus men's programs that were added and women's that were added. We see on the men's side over 170 wrestling programs were discontinued and gymnastics over 50. And on the women's side, we actually saw more gymnastics programs at 100 being dropped by women's programs and field hockey close to 30. On the men's side, soccer added over 130 programs, and baseball 85 and basketball at 82, while women's programs that were added 243 for the track and 108 lacrosse programs and just over 100 for swimming programs. So in that 15-year period from 98 to 99 to 2002 to 3, the data on adding and dropping programs, all Division IIIs, we had 383 men's programs that were added and 331 men's programs that were dropped. So over 50 programs were gained. At the Division I level, 26 men's programs were added, 235 were dropped for a net loss of 209. Wrestling, swimming, tennis, gymnastics, and rifle were those numbers. And then 1,985 women's programs were added. 71 women's programs were dropped. Primarily were badminton, fencing, skiing. So almost 2,000 were the gain in the Title IX data that we have. And so we're going to use one from pretty close by here, just as an example. University of Maryland, in their 2012 report, shows a comparison and a breakdown of the programs that they have, and then also the numbers of participants as of the day of the first scheduled contest. And you can see as you go through here the data comparable from the men's side versus the women's side and the programming that they have. Essentially on the men's side here you can see 321 versus the total of 288. And then you can see here in the next slide there's the breakdown in the numbers as far as revenues and money. And then the last slide here shows the comparison with the basketball and football programs compared to the women's programs and the revenue that was either brought in or the expenditures that were made for both men and women's teams. And the last thing I want to get to before I finish up is the NCAA link that we have on achieving gender equity. Now this is a manual that has a lot of references that you can use to look through and a lot of data if you ever need it for research and reporting. And that's all I have for this class, and I'll talk to you more in the next.